So instead of spending too much time on this, we're going to jump past it. We're going to jump past the questions as well and get into House Bill 1236. House Bill 1236, just like Senate Bill 5160, is already effective. It's been effective since May 10th. And the bridge moratorium, if you'll recall from that discussion earlier, expressly allows evictions under House Bill 1236 to move forward subject to the restrictions of the bridge moratorium. So understanding these is going to be vital for both tenants and landlords alike, because there's some specific information. Now, instead of being able to terminate a tenancy, you have to fit into, a landlord would have to fit into one of 16 specific just causes in order to terminate a tenancy in most situations. So knowing those is kind of important. The first thing to know, we have to backtrack a little bit. So the general rule prior to COVID was that many tenants in Washington who were month-to-month tenants were subject to the landlord terminating their tenancy for no reason whatsoever, if they were given a 20-day notice to terminate tenancy. And that had been around for a significant period of time. City of Tacoma required 60 days notice to require or to terminate a month-to-month tenancy. That's all changed now. And so the new baseline rule that you should be getting familiar with in your head is that a landlord may not evict a tenant, refuse to continue a tenancy, or end a periodic tenancy except for the causes, the just causes enumerated in House Bill 1236. So that's the baseline rule that you're going to be operating off of. And in difficult to understand language, if anybody actually wants to go through and read this stuff, there's 4 separate specific rules as concerning terminations of tenancy before we get into the just causes. The first one is that anytime a tenant or a tenancy is periodic or month to month, then just cause must be used in order to terminate that tenancy. One of the 16 just causes, the landlord has to present that in order to terminate the tenancy.
You're eating something, that's why. and they.
Alexis, quick with the mute button. So so you're going to have to use just cause, but let's take a beat here for just a short second and understand the difference between a fixed term tenancy and a month-to-month tenancy or periodic tenancy, because this is important to understand when we talk about the 3 rules that come up. So fixed term tenancy is a lease agreement for a certain period of time, right? 6 months, 9 months, 12 months, something like that. A month-to-month tenancy is a tenant who pays their rent at a certain date, beginning of the month, and is able to stay there for that month. And then the next month comes, they pay their rent, and they're able to stay there for that month. Certain fixed term tenancies, in fact, the majority of them out there, in my opinion, automatically at the end of the fixed term roll over into a month-to-month tenant. So there's a lot of month-to-month tenancies out there. All those month-to-month tenancies are going to require just cause. Then you also have the situation where tenants could be living on a fixed term in unexpired lease agreement, whether it's 6 months, 8 months, 9 months, whatever the length is. But know that terminology because it's somewhat important. It's very important, actually. So if a tenancy, the second rule that House Bill 1236 gives to us is that if the tenancy is for a fixed term of less than 6 months, but rolls over into a month-to-month tenancy after those 6 months, then you have to use just cause to terminate it. All right, so these are tenancies that 6 months or less, like a fixed term of 4 months, and then it rolls over to month, have to use just cause in order to terminate that. The third rule that we get from House Bill 1236, if that a tenancy is for a fixed term of between 6 and 12 months, then rolls over into a month-to-month tenancy at the end of those 6 to 12 months, you can terminate for no cause, but only with the 60 or more days notice at the beginning of that first fixed term period, that initial fixed term period. Once the tenant goes past that, then your just cause applies at any time thereafter. So this is like for new tenancies where a tenant moves in, has a fixed term between 6 and 12 months that rolls over to a month-to-month. Landlord has a no cause termination here, but just that one time, right? So if you don't exercise it there, it's going to become month-to-month afterwards. And the fourth rule, which may be even a little bit more confusing, applies to fixed term tenancies that do not roll over into a month-to-month tenancy at the end of it, right? The exact language is you're here for 12 months, 9 months, and then there's nothing beyond that, right? It's a fixed term tenancy and that's it. Then the landlord can use a no cause termination in these specific situations, but only if the original fixed term was for 12 months or more, or for consecutive 6 month or more periods that exceeded 12 months, right? So the total of it had to be over 12 months. and the tenancy never became month to month or periodic at any point in time. All right, so this is a very specific situation that could be used for no cause termination. It's either you're at the end of this initial 6 to 12 month period if it rolls over to a month to month, or you're on a fixed term tenancy that has to be at least 12 months going forward. You could terminate at the beginning of this, with 60 days notice, as long as there isn't a month to month tenancy at any point in there. For all tenancies falling outside of those 4 specific situations, you have to use just cause. And so just cause, like I mentioned at the beginning of this section, is really the baseline rule that we're following here with these narrow avenues that that landlords have for being able to use no cause termination. The general rule is just causes. That's where we're at. That's what the legislature said. Any of these tenancies automatically converts to a month-to-month tenancy in House Bill 1236. So if you don't exercise that right if a landlord doesn't exercise that right to termination, this is going to roll over into a month-to-month tenancy, and it's going to require just cause. So there's really all of these funnels go into just cause with just a few little off ramps for landlords. So you really have to be clear on knowing what those are. Tenants, on the other hand, could still terminate their tenancy with 20 days notice, either prior to the expiration of the fixed term, or if it's a month-to-month tenancy, at any point they could give 20 days notice before the end of that monthly period and terminate. So they're not bound, tenants are not bound by just cause, just landlords are, and there's very specific rules for that. There is one exception here, and for a limited period of time. So up until the end of September of this year, landlords can offer to tenants who are month to month right now a new fixed term lease. And if the tenant agrees to sign that new fixed term lease, then the landlord would be able to exercise their rights to terminate for no cause with 60 days notice at the end of that initial term, right? This is a very specific situation. It has to be a fixed term lease that doesn't roll over into a month to month tenancy, and the tenant has to agree to sign that. So it may be a little bit confusing, like why would a tenant choose to avoid their just cause protections and sign this new lease agreement that potentially leaves them open for a no cause termination at the end of that term? Well, it's a trade-off. So we know that rent increases are back on the table under the bridge moratorium. We know they're allowed under the Residential Landlord Tenant Act. And so if somebody signs a fixed term lease, if a tenant signs a 9-month lease, they know for 9 months their rent is locked, right? A landlord isn't going to be able to increase it for that 9-month period. And so there's a certain amount of security that's in there, which a tenant may want to take. On the other hand, a tenant could just say no to that contract that you offered to them and choose to proceed with their just cause protections. But they would also be open for these rent increases or rule changes that could happen to any month-to-month tenant. Nothing has changed in that regard. So it's kind of a complicated calculus or decision for any tenant to make. But landlords do have that option until September 30th to offer that to tenants and convert them to these fixed term leases under that specific situation. So with all that out of the way, let's talk about the 16 just causes that operate outside of those fixed tenancy terminations that we just talked about, or fixed term tenancies that we had just talked about. So if a landlord is required to use just cause, and remember just cause is basically the baseline going forward, there's 16 different just causes, but there's some important things that you have to know that apply to all 16 of them. The first one is there's a stringent penalty requirement. A landlord who removes a tenant in violation of a just cause requirement is liable for the tenant for the greater of all economic and non-economic damage, which is important. We're not talking about actual damages, non-economic damages, or 3 times the monthly rent plus attorney's fees and court costs. So you want to know the just cause, because if you're dabbling outside of that, there's some stringent penalties that are on the table now. All of the notices within the just cause require specificity. So a tenant or a landlord in their termination notice, whatever the 16 just causes is, has to identify all the facts and circumstances known to the landlord at the time to support the notice. A landlord may, down the road, present additional facts, but only if such facts were not known or available to the landlord at the time of issuing the notice. So all that stuff you put on the notice, a landlord kind of locked into that. That's the facts you're running with from there on out, unless you had no opportunity to be able to know that beforehand. And the last thing is, pay attention to the effective termination dates. When can you terminate a tenancy under these just causes? because, you know, to me, it was a bit odd the way the legislature chose their language, but they were very specific in their language. Some of these notices have to be given before the end of the monthly rental period or the end of the fixed term lease or rental period, I should say, in general. And others appear to be just straight calendar days. Like you could give 90 calendar days and you could terminate a tenancy in the middle of the month. It's a big change from where we were at before, but that's also what the language says in House Bill 1236. So pay attention to those. The first cause is going to be non-payment of rent. So non-payment of rent is 14-day pay or vacate notice, just like it was before the pandemic. So this is going to be back on the table. But you have to remember, before this really starts flying, is Senate Bill 5160 has changed the standard 14-day pay or vacate notice. For a period of time, 6 months past the public health emergency, landlords are going to have to be offering these reasonable repayment plans for non-payment before moving forward with this. And eviction resolution, it should be pilot program, is still going to be applying for non-payment of rent situations. So we're subject to the bridge moratorium, we're subject to Senate Bill 5160, but non-payment is the same as it was before. The timing of these notices, it could be given at any time after the non-payment, right? So you're not locked into a specific termination date or anything like that. You give a 14-day pay or vacate notice. Just cause, the second just cause is very similar to what existed pre-COVID. And that's for, you could give a tenant now, you could give a 10-day notice to comply or vacate for if they're breaching the terms of their lease agreement, for non-monetary breaches of their lease agreement. The language here is a little bit specific. I'm not sure how important the actual nuance of the language is, but for subsidized housing, a 10-day notice could be given for any substantial breach of a material program requirement of the subsidized housing. And for all other tenancies that are non-subsidized housing, a 10-day notice can be given for a breach of a material term in the lease or rental agreement or a breach of a tenant obligation imposed by law. So those are the basis for giving the 10-day notice. The timing, just like the 14-day notice, could be given at any time after the breach occurs. So there's no specific timing that applies to this. The third is, again, similar to what existed pre-COVID, is that you could give a notice to requiring a tenant a 3-day period to quit the premises if they engage in waste or nuisance upon the premises. There's no cure period for this. Unlike the 10-day notice to comply or vacate, they fix the problem within 10 days, you can't go forward. This is you're telling them to get out within 3 days because they're causing a waste or nuisance. Nuisance is generally understood as a substantial and unreasonable interference with the ability of other people to use their premises or enjoy their premises. And the timing, again, this could happen anytime after the tenant permits or allows a waste or nuisance to occur on the property. So there's no specific timing here. This is where things start to get different. So the fourth just cause is if the landlord intends to occupy the premises. And we knew during the whole moratorium period that you were able to give a 60-day notice of landlord's intent to personally occupy the premises. So this is similar. Now it's changed to a 90-day notice, but it's broadened a bit as well. So now there's a 90-day notice that the tenant has to vacate because the landlord in good faith seeks possession for the owner or immediate family to live in the premises as their principal residence. So there's some things that we could look into there and some things that we need to know. Immediate family is defined pretty broadly in House Bill 1236, so it includes all those things that you see listed there. It's not just that the owner is going to be moving onto the property. It could be immediate family. One of the restrictions is that there can't be a substantially equivalent unit available in the same building. So you can't ask the tenant in unit A to move out when unit B is available and is substantially the exact same thing. If there's a little bit of an oversight mechanism in it, if the owner or immediate family fails to occupy for 60 consecutive days in the 90 days after the termination of the tenancy, it's presumed, the court's going to have to presume that the landlord acted in good faith or bad faith. And remember, there's those penalty provisions that if you evict somebody in violation of this, that you could face some pretty substantial penalties. The timing on this one is, well, it seems like it's just 90 straight calendar days if you read the language of the statute or House Bill 1236. And so you could give this anytime that basically at any day of the month that you want to the tenant. However, there is a restriction on it that 90 straight calendar days would only apply if this is a month-to-month tenant. Nothing If somebody's on a fixed term lease, so if a tenant's on month 3 of a 12-month lease, you can't give them the 90-day notice. Your 90-day notice has to tell them that they have to leave at the end of the rental term, not just 90 straight calendar days. So you can't terminate in the middle of a unexpired rental contract. The 5th just cause is if somebody is selling a single family residence. Again, similar to what we saw in the moratorium, where there's a 60-day notice of intent to sell, but now it's a 90-day notice of intent to sell. And there's some restrictions on this. So if you give a tenant one of these notices, the owner elects to sell, the landlord, at a minimum, to show that they're going to be selling the premises, has to list it at a reasonable price with a listing agency. And if the owner removes that listing within 90 days or doesn't list it as a reasonable price within 30 days after giving that notice, after the person moves out, the court has to assume that this is given in bad faith, right? And again, you have those stringent penalties that apply. So there's some requirements on it. This one, the timing of it, you could give it in 90 calendar days with the same restriction that we saw before. You can't give 90 days if somebody's in an unexpired lease term. So if they're month 3 of a 12-month lease, you have to give them 90 days notice that they have to move out at the end of month 12, right? It isn't going to be just 90 straight calendar days unless they're a month-to-month tenant. This is really nothing new, so we're going to go over this really fast. This has existed in Washington law before, but just the landlord intends to demolish, substantially rehabilitate, or change the use of the premises. This is demolish means exactly what it sounds. You're going to be taking the whole thing down. Change in use means a conversion of the premises from any residential use to any other type of use. And substantial rehabilitation means that there's going to be some sort of repairs that require permits. So that applies. You have to give 120 days notice in this situation, but that already kind of existed in Washington state law, so it's nothing new. This one as well is nothing new. Conversion to condominiums. In my experience of doing this for 6 or 7 years, haven't actually come across this yet, but I know it's out there. If a landlord intends to convert the apartments into a condominium, there is a 120-day notice. The entire process is complicated, so you probably want to look into the statutes, but just know that that is a just cause. If the just cause number 8 is if the premises is condemned. So if a governmental agency condemns the unit as being uninhabitable, then the landlord could say that's just cause to terminate the tenancy. And it requires the landlord to give 30 days notice to the tenant if the premises has been condemned and if continued occupancy would result in civil or criminal penalties for the landlord. And there also is a little bit of an out for landlords in this situation. If the condemnation order doesn't allow for 30 days notice, then they could give as much advance written notice as is possible in order to still comply with the order. One thing to know about any condemnation when the unit is uninhabitable, landlords are probably going to be required to pay relocation assistance to that tenant, but you're able to terminate the tenancy. That's a just cause. The timing of this one, again, is straight calendar days. Landlord has to provide 30 days notice in order to do that when the premises is going to be uninhabitable. The just cause number 9 applies in a very specific situation. And this is where a landlord lives in shared housing with their tenants, right? So the landlord lives in one bedroom and is renting out another bedroom in the house. This really isn't even a just cause at all. It doesn't seem like one to me. Landlord could give a 20-day notice, very similar to what existed in landlord tenant law prior to House Bill 1236. This applies when the landlord, like I said, rent space in the landlord's dwelling unit. And in order to rent space to be considered for this, to be able to give a 20-day notice to one of these tenants, there has to be a common kitchen or common bathroom area. So you're really, for the most part, looking at like these shared dwelling units where it's really a house or something like that. Maybe it applies in other circumstances, but that's really going to be where most of them apply. The 20-day notice is not calendar days. You have to terminate the tenancy at the end of the rental period, the monthly period, or at the end of the rental period, whichever one is going to be longer in that situation. Transitional housing. This one may not apply to a lot of standard residential landlords. It probably won't for most, but transitional housing is housing units that are owned, operated, or managed by a nonprofit organization in which supportive services are offered to those tenants for a period of not more than 24 months. These would be things like possibly, people who are substance abuse recovery, things like that, possibly DV survivors, something along those lines. But this applies when transitional housing, where they've provided 30 days notice to the tenant to terminate. When the program expires by its own terms, the tenant has aged out of the program, right? So if it's for youth that are facing homelessness, or the tenant has completed the program. And the termination, if you're going to terminate a tenancy for any other reason outside of these 3 specific reasons for transitional housing, then you're going to have to use one of the other just causes. And the timing has to terminate at the end of the program. So this applies in a very specific situation as well. Just cause 11 has probably been subject to some confusion, so we should make sure we're clear about this. Failure to sign a new rental agreement. So landlords can evict when a tenant refuses to sign a new rental agreement, but only under very limited circumstances. Remember, we talked about just cause as the baseline rule, but we'd also talked about some of those fixed term tenancies, right? That you could keep a tenant on fixed term tenancies if they don't roll over to month and eventually terminate the tenancy with no cause if it lasts more than 12 months. This is really where that situation applies. So the new rental agreement, in order to terminate for this reason, for this just cause, you have to offer the tenant a new rental agreement at least 30 days before the expiration of the current rental agreement. Any new terms and conditions within that rental agreement have to be reasonable. We all cringe at that reasonable. I know it's always a source of discussion on these presentations, what reasonable actually means. And there's a broad range of arguments, array of arguments that could be made for what's reasonable and unreasonable. But to be clear, this never applies to a month-to-month tenancy. Right. So if you have a month-to-month tenancy, you can't just hand them a new rental agreement and say, look, I gave them 30 days to sign this thing. They didn't. I'm going to terminate their tenancy for this reason. This only applies when fixed term tenancies are reaching the end of their conclusion. The timing, there's no additional notice required. The tenancy terminates at the expiration of the rental period if the tenant was offered the lease and didn't move out. After, if they choose, and didn't accept the new lease, if they continue, they're what's considered a holdover tenant at that point. Lying on a rental agreement. So this is kind of dishonesty in the rental agreement process. Landlords can give a tenant a 30-day notice to terminate a tenancy when a tenant provides intentional, knowing, and material misrepresentations or omissions on a rental agreement. And so what we're looking at here, that language is pretty bulky, right? So minor mistakes, things that they didn't knowingly make, they kind of like fudged this number or didn't remember that number exactly well and put something on there. Like that's probably not gonna be it. You have to show the intentional knowing. You also have to show that the representation, the misrepresentation on the rental agreement would have caused the landlord to make a different decision at the time, right? They wouldn't have ever rented to the person had they known the accurate information. This one is, again, straight calendar days. So you could give this to a tenant anytime after you discover that they made a misrepresentation, a material or knowing intentional misrepresentation. And we're going to come back to this in a second because it makes sense. It's pretty straightforward. The 13th just cause is one that's going to be interesting to see in practice. So landlords can provide 60 days notice to terminate for, and as House Bill 1236 puts it, a legitimate economic or business reason not covered or related to a basis for ending the lease under other just cause reasons under House Bill 1236. So this is kind of a catch-all provision. Like the legislature put this in there that there's some circumstances that they didn't include within those 16 that is a legitimate reason for ending a tenancy with 60 days notice. And so it's kind of a catch-all. Who knows what legitimate economic or business reason really means or doesn't mean. I'm sure we're going to see some situations. But the one thing you know for sure is you can't use this as a basis for avoiding one of the other types of just causes. So, but this one also has an out for tenants where even if you serve this notice and the notice is valid and you go all the way to court and get your eviction order, the court can order the tenant that they have an additional 60 days to move as long as they continue paying their rent during that period of time. So there is like a weird out, and this is the only one that has that weird out expressly written into it for tenants that they could stay a longer period of time. The timing is the end of the rental agreement. So the landlord has to offer at least 60 days written notice to vacate prior to the end of the monthly period or the end of the rental agreement, whichever is longer. So it's not calendar days. Just Cause 14 causes some confusion, but I think it's pretty straightforward. This is for repeated lease violations. This is essentially when a tenant has breached lease violations and received multiple 10-day notices to vacate, every time they end up applying. So you can't go forward with the eviction on the 10-day notice. But if you have this kind of tenant that's always breaking the rules for different reasons, and you have to give them a 10-day notice, four or more within 12 months, then that is an independent reason to terminate the tenancy. So each of those 4 violations within the 12 months has to be written. It has to be specific and has to provide the tenant an opportunity to fix the problem. It also has to tell the tenant, like, look, 4 of these in 12 months and it's going to be game over for you. After the four different violations occur, then the landlord can use this as just cause to terminate the tenancy. But in order to do so, they have to give the tenant a 60-day notice to vacate the premises, right? That specific 60-day notice has to include all those prior violations, notices of violations to let the tenant know. And the tenant can challenge any of those prior violations when they show up for court and show, like, no, I actually didn't actually have 4 violations. Yeah. The timing of this is, again, you have to be very wary of the language. The landlord can either terminate the tenancy on a specific end of the rental term, so 60 days before the end of the rental term, or choose not to renew the rental agreement in whole, but you have to give 60 days notice in advance of that. Again, we're back to that month 3, 12-month thing. You'd be able to end at the end of the 12-month period, not in between when they're on a fixed term tenancy. This one's a little bit quizzical to me. Just cause number 15 is sexual offender registration. The landlord could provide, it's just cause, they could provide a 60-day notice to terminate a tenancy if the tenant is required to register as a sex offender during the tenancy, or if they fail to disclose a requirement to register as a sex offender when required in the rental application. So the reason why it's a little bit odd to me is because it appears that a tenant who lies about their rental amount or their prior evictions could be evicted under a 30-day notice under the earlier just cause, and somebody who lied about being a sex offender gets a longer period of time. I don't know what to make of that, but that's kind of what this says. The timing is, again, a longer period of time. It's especially when it comes to lying on the rental application. The specific lie on a rental application entitles the tenant to 60 days notice in advance of the rental period or the end of the rental agreement. Remember, can't terminate in month 3 of a 12-month lease. This last just cause that we're going to get to is sexual harassment. A landlord could provide a 20-day notice to vacate if the tenant makes unwanted sexual advances or other acts of sexual harassment towards basically anybody, right? Who's on the premises, or the landlord or the landlord's agents. Then this counts as a just cause to terminate the tenancy. Again, specific timing, 20 days prior to the end of the monthly period or the end of the rental agreement. Again, that 3-month in the 12-month thing, you have to give them until the end of the 12 months if they're on a fixed term lease agreement. The last thing, which some people consider this a 17th just cause, I personally don't, but it's on there. It has to do with holdover tenants. This is when a tenant of record, the person you sign the rental agreement with, vacates the premises, and there's people remaining on the premises who have lived there for, I'm going to go into it in a second, who have lived there for at least 6 months. The landlord can give a notice to those remaining tenants, a 30-day notice, to either vacate the premises or apply to become tenants under that previous person's rental agreement. Not necessarily under that previous person's, but a new rental agreement. The notice does not apply. This particular notice does not apply in subsidized housing situations. There's a specific exception within House Bill 1236. When these holdover applicants, if they choose to apply for a tenancy, the landlord can use the same screening criteria that they did for the original tenant that had vacated. If they choose not to apply for a tenancy, then they become holdover tenants, and the landlord could pursue eviction after the 30 days. And the timing on this is no specific timing. You can give 30 days whenever you discover that this is a situation that's going on, that the original tenant had vacated. Yeah. And I know that's a lot for House Bill 1236. There's a lot of specifics to go into it, but this is the new reality. This is where we're at. And anybody that thought the just cause was something different, it's not. You have to have a reason, almost always, to terminate a tenancy going forward in Washington.
Wow, thank you so much, Mark. We do have quite a few questions here. And just a reminder, I'm going to send the PowerPoint out, and I have everybody's email addresses because you registered for this session. And so I will send everybody who registered the PowerPoint along with important links and documents. Let me see. So I'm going to scroll up to the first question. So this is from Tashana. Are any of these forms going to be created that also include the required HUD language, or should I make my own?
The question refers to the notices to terminate tenancy under House Bill 1236. Is that correct?
I am not sure.
Right? Okay, so when it comes to form language for House Bill 1236, the pay or vacate is the only one that has form language that exists. All these others don't have form language for them. So, you know, you're going to have to come up with something for them. But landlords have always been able to do it in the past. So I have no reason to think they won't be able to do so now.
And then we have about 3 questions that Nicholas can help us answer. So can nonprofits apply for landlord mitigation fund?
Yes, nonprofits can. The only restriction is on the damage relief program that housing authorities cannot apply. So yes, nonprofits are certainly welcome to apply, and same with master lease situations where a nonprofit is master leasing from a landlord. They can apply to these programs. In fact, they'll be required to apply to these programs when they're the ones writing the lease documents and making the repairs.
Thank you. Will it take a year to get the funds from the landlord mitigation fund?
And when we're saying the landlord mitigation fund, I'm assuming you're referring to the damage relief program, which was the original landlord mitigation program, but unfortunately the laws keep piling these programs on top of that. So we changed the names to avoid any potential confusion. So the damage relief program, it has priority payment status under Senate Bill 5160. So all claims there will be paid monthly, and then the remaining amounts will be used for the COVID relief and the limited landlord relief programs, or sorry, the tenancy preservation program. Limited landlord relief program has its own funding. One point on that note, though, the tenancy preservation program, which Mark touched on as well, one of the things that's going to happen when you're in court and you're requesting it or the tenant's requesting it, you're probably going to get a writ of restitution and a stay action preventing the landlord from acting on that writ of restitution if they can apply and be approved for this program. So you'll be approved, but remember, payments may take up to a year to receive. So if it's written in that you have a 30-day window to receive payment to avoid that writ of restitution, that may impact your decision on how to use that, and it may also bolster a defense on not using that program if you're in court for eviction. We'll post this on the top of the tenancy preservation page before August 1st, so that you can see that the projected payment time may be a full year before you receive payment in that program.
If the tenant requests the funds from Department of Commerce at an eviction, can the request be denied? I think you just kind of talked about that a little bit.
Yeah, in court, it's judicial discretion. So the court has to find the tenant eligible first. And then the landlord could state a defense that they're backdated. They can't pay this for a year. We can't wait for a year for this payment. It's really going to be up to the judge at that point.
Thank you. And then somebody asked if landlords need to use the same repayment plan for THA participants. And I answered yes, use the same repayment plan you would with any tenant. With the changes from House Bill 1236, when will the City of Tacoma resource package be updated? or will the package be required at all anymore?
That would be a great question for the city of Tacoma. I don't work for them. I'm sure they will update it. I'm sure they'll be in contact with me to assist in that. But it will be updated at some point. I don't have a time frame for it though.
Okay. A fixed lease for 6+ months with a holdover after means a landlord would have to give termination notice by when? Please clarify.
Yeah, so go back and look at rule number 4 in the PowerPoint, and this PowerPoint is going to be sent out to you. So 6 months wouldn't work in that situation. You would have to have consecutive 6-month periods that exceed 12 months, right? With no month-to-month tenancy in between. It wouldn't apply for just a 6-month tenancy with no rollover to a month-to-month tenancy. And that's why there's that other just cause provision that says if you offer somebody a lease agreement and they don't sign it within 30 days, that you could seek your termination then, right? Because a landlord, in order to use that, has to have at least a lease that's 12 months or longer, or consecutive leases that exceed 12 months or longer. So those two provisions kind of play into one another. But assuming you have done all that properly, then it was a 60-day notice before the end of the lease term, right? Hopefully that answers the question. But I think if you go back and review the PowerPoint once you get it and look at rule number 4, and then look at, I believe it was just cause number 11, and put those two together, that you'll see how they work together.
Does the carve out period require a 12-month fixed term lease if the previous lease was 12 months and went month to month during COVID?
I'm sorry, can you repeat the specifics of that again?
Yes. Does the carve out period require a 12-month fixed term lease if the previous lease was 12 months and then went month to month during COVID?
Yeah, 100%. So that tenant at this point is a month-to-month tenant, right? So that narrow carve-out period that lasts until September 30th is for landlords to offer new lease agreements or fixed-term agreements to tenants up until September 30th to potentially maybe avoid this whole just cause thing. But right now, the way that's described, they're a month-to-month tenant. You could offer them that lease agreement. They could also say no to it. It was that calculation that I went into. Do they want to agree to this fixed term, or do they not want to and just take their chances with just cause?
Is there a limit to how many increases a landlord can do per year, or a limit of the increase? And I'm assuming they mean rent increases.
That's a good question. I'll throw it over to Jim because I would love to see this case.
Jim? I'm not sure.
So I'll answer the first portion of that question. So under RCW 5918-140, that's the statute that you want to look at. There isn't any language in there that probably isn't any language in there that prevents as many rent increases as a landlord wants to give. Like I said, I'm not going to jump too far into the specific facts of this situation because I would love to work with that tenant and see that situation. And I think we would have some pretty good options there. So sometimes if it doesn't smell right, it ain't right.
Thanks. And Jim's no longer on the call, just so you know. What if the tenant damages the property on the way out or during their tenancy? Repairs can take longer than 30 days. How do we show that our intent to sell is real?
So I think you guys, on my personal opinion, I think you guys got hosed there. I think anybody who's selling got hosed on that particular just cause because it has a lot of requirements. You can even look at somebody like who's a mom and pop landlord. They own one rental and somebody's been living in it for 20 years and they just want to remodel it on their own and not have the expense of contractors. They're still stuck into this 30-day window, right? That 30-day window is rebuttable, right? So if somebody were to bring an action against you, you could always go to the court and explain your case. Like, this is why this didn't happen. But it wouldn't, but the statute does say you're supposed to do this within 30 days. Otherwise, the court has to begin that proceeding thinking that you have violated that just cause, and you have to prove that they didn't. That's the way to look at it. So you still have that option. It doesn't mean you're going to be in any sort of trouble. There's the presumption is there that you're in trouble, but you could always rebut that presumption in front of the court and show them this is why I wasn't able to do what the statute requires. But, you know, personally, I think landlords kind of got hosed by that language.
Can just cause number 14 be for several different violations?
Yeah, it just, you know, that language there has to be specific, or I'm sorry, separate occurrences is what it is. And separate occurrences could be like the tenant had a loud party in May, and then they had a loud party in July. Those are two separate occurrences, right? There's two separate loud parties. They didn't last. It wasn't Mardi Gras. It didn't last for this entire period of time. And so, yeah, those would be separate incidents.
And would they serve a 10-day for each violation?
I'm sorry, I was being passed keys. Can you repeat that?
Yeah. And would landlords serve 10 days for each violation?
Yeah, so remember there's two different just causes that apply here. Just cause number 2 and then the other one. So just cause number 2 allows you to give a 10-day notice whenever there's this material breach of a lease term, right? And the tenant has 10 days to comply with that and to fix the problem. Otherwise, you could go forward with your eviction just on giving one of those notices. But the repeated violations is when when a tenant constantly has these problems, but also constantly corrects them. They're just kind of a problem for you, right? You're constantly having to give these notices. So yeah, I think I lost the question there, but there are two separate ones there. Okay, well, what was the original question again?
So the original one was about just cause number 14. And the separate question was actually, what if they are violating more than one lease rule? Do they give 10 days for a 10-day notice for each violation?
So remember, you have to identify all the specific facts. To me, that 10-day notice to breach of lease terms has to include all the relevant facts that you know about the situation, including those other breaches. So you can't give 4 different notices for 4 separate breaches that are all occurring at the same time. You have to put those all onto one 10-day notice to comply or vacate. And then if they cure, then the other one comes into effect. You can't, again, if it doesn't smell right, it ain't right. That isn't what the legislature intended for the way for those 4 notices to operate before terminating the tenancy.
If the tenant violates a health and safety violation, if the tenant violates a health and safety violations and does not remedy it after 4 notices within 12 months, can we ask the tenant to leave?
If they violate, what was it, a health and safety?
Yeah, if they have health and safety violations.
So that I would actually refer you to speak to an attorney about that, because so what we're talking about, House Bill 1236, the Residential Landlord Tenant Act still exists. And there's specific things that you have to do if a tenant's causing a health and safety condition that's imminently hazardous to that tenant or other tenants. So that, I don't even think that's really contained within House Bill 1236. There's a very specific other mechanism and rights that landlords have in that situation. Or look up the RLTA yourself, but that isn't within House Bill 1236 as a just cause.
During the moratorium, we have been unable to deliver breach of contract notice in the form of a 10-day to comply or vacate notice. Would multiple letters to the household suffice to move forward with the eviction process?
No, so you have to serve the notices, and the notices have to comply with the specific procedure that the RLTA requires. Informal notices, things like letters, and because I know that you couldn't threaten, like you were stuck in a hard position during the moratorium, and that's what we're coming out of. But it doesn't allow you to avoid what you have to do in order to seek a proper eviction. So unfortunately, even if you sent these communications to a tenant saying like, look, you're doing stuff wrong without any threat to evict, that wouldn't comply with the notice requirements that you have under the Unlawful Detainer Act and the Residential Landlord Tenant Act. It's unfortunate, but that's kind of the situation. We're coming out of the moratorium. Let's hope that all of that's in our rear view. But that's what it was.
And then I received a private message to remind everybody that the rental associations like Rental Housing Association of Washington, Washington Landlords Association, or Washington Multifamily Housing Association has all of the forms that you'll need, and they provide a lot of support for their members. Let's see. So Sarah is asking, so a tenant can refuse to sign a 6 to 11 month lease offered during the carve out. And what if the lease included a rent increase? Would that be void if they don't sign?
No, so a tenant's able to, so during that carve out period, you can't force the tenant to sign a new lease agreement. It is entirely, you're offering them that new lease agreement. If they agree and if they sign, then they're going to be able to, then you're going to be able to pursue your no cost termination right potentially at some point in the future, but you can't force them. Nothing is to be voided, right? If they don't sign that lease agreement, then there's nothing to be voided. If they do sign the lease agreement, then they're going to be bound by that.
And I just want to give a special thank you to Mark, Nicholas, Valeri, Jim, and Marilise for taking all of this time to talk to all of us about all these new changes that are going on and the countless amount of hours and blood, sweat, and tears you guys have put into the work that you're doing. So thank you very much. And it has really been an honor to host this meeting with you guys. And everybody else that attended, thank you so much for your partnerships.